Odette is a lawyer and the executive director of the Equal Justice Alliance, whose mission is to defend freedom of speech and freedom of assembly and to repeal the Animal Enterprise Terrorism Act. Odette is a graduate of Brooklyn Law School. She has a master's degree in finance from NYU, and she's also a graduate of Barnard College. Welcome, Odette.
Hi, everyone. I'm coming after lunch, so people are still gathered in the garden and they're having great conversations, and that's what this whole event is about. It's about networking and for us to feel the cohesiveness of our community. Come on in, everyone. I'm going to talk about the Animal Enterprise Terrorism Act. Who has heard about the Animal Enterprise Terrorism Act? Most of you. What is terrorism? There's no consistent definition. The State Department has one definition, Homeland Security has another, the FBI yet another, and then there's the USA Patriot Act. So for purposes of this discussion, let's look at what the USA Patriot Act states. Domestic terrorism involves acts dangerous to human life, coercing a civilian population, and affects government conduct by mass destruction, assassination, and kidnapping. David Shipler wrote an op-ed article in the New York Times, and he said, and he focused on the false dichotomy between liberty and security, that in order to be more secure, we have to give up our rights. That is a false dichotomy. I can give up your rights for my safety. It's always with the thought that it's somebody else's rights that are being given up, not yours. Apprehend the terrorist and protect the upstanding citizen. But ultimately, it starts to invade the rest and permeate the rest of society so that we all become enmeshed in this, and then all of our rights are compromised. This is a picture of an onion. It's a very nice onion. It reminds me of the Animal Enterprise Terrorism Act because it has lots of layers and it smells and it makes you want to cry. The elements of the AETA, or ADA, are using a facility of interstate commerce. So if you use your cell phone, a fax machine, your regular phone, that's sufficient. It doesn't have to be across state lines. Intend to damage or interfere with an animal enterprise? Well, what's interference? What's damage? That's not defined in the statute. To cause real or personal property loss. So it has to do with your personal property or your real estate. And the next slide. And 4 is to intend to cause a reasonable fear of death or serious bodily injury by a course of conduct involving threats, vandalism, property damage, criminal trespass, harassment, or intimidation. This is a very strange construction because basically what it's saying is that even if you just trespass, that's sufficient to cause somebody a reasonable fear of serious bodily harm. That doesn't make any sense. Does that make any sense whatsoever? No. The whole statute doesn't make any sense. And then there's conspiracy where there's 2 or more people who are in agreement to engage in illegal activity. But I'd like to focus on course of conduct. And that means 2 or more acts evidencing a continuity of purpose. So what do we have, a thought crime now? If you have a particular ideology, all of a sudden that becomes a crime? That doesn't make any sense. Next, course of conduct. Thanks. Course of conduct means that these acts don't necessarily have to be illegal. The purpose doesn't have to be illegal. It doesn't necessarily have to be done by the same person. No conspiracy is required. There's no temporal concurrence or imminence. So there can be 2 or more people having the same ideology where the acts can occur simultaneously at the same moment, or days apart, weeks apart, or months apart. For instance, if you're putting a demo together and everything goes well, and then all of a sudden, a few weeks later, somebody comes and spray paints the house or the establishment. They can't find who did that. But what they can do is they can find the person who put together the demonstration, and this statute allows people to be brought in, even though they themselves have not committed any illegal acts. Next. So this is basically a RICO statute for activism. RICO is the anti-racketeering law that the government uses against the mafia, organized crime. Because if they're engaging in a similar enterprise, that's sufficient for the prosecution to bring a case against them. Under the AETA, continuity of purpose. You just have to have a similar ideology. That doesn't make any sense, does it? And the penalties are pretty excessive. In 2005, the federal sentencing guidelines for sexual abuse, manslaughter, and larceny were anywhere from 4 months to 4.5 years. But if you cause the loss of monies or the loss of profits to a business of over $1 million, you can get up to 20 years in prison. Does that make any sense? No. This is a nonsensical law. Now, the supporters of ADA say that, oh, but the statute exempts First Amendment activity and lawful boycotts. It's right in the statute. But that's at the end of the statute. And what it's doing is it's talking about both sides of its mouth, because actually it is affecting First Amendment rights and lawful boycotts. Because again, if you affect corporate profits, you can spend some time in prison. And that makes no sense. And boycotts are part of American culture. That's what we did which preceded the American Revolution, when we boycotted the British. There was a case, Shack 7. Who has heard of the Shack 7? Okay, a few of you have, and many of you have not, so I'm going to go over this. The Shack 7 is dog hunting and animal cruelty. And that was an organized movement where the goal was to boycott Huntington Life Sciences. That is probably the second largest animal testing company in the world. There was undercover video that was publicized, and ultimately what happened was that people wanted to shut the place down. And there were boycotts around the world against Huntington Life Sciences. The Shack 7 probably put together one of the most successful economic boycotts on the internet in the United States. Fortunately, they were all convicted of animal enterprise terrorism. So what did their campaign consist of? Well, their campaign consisted of targeting the suppliers of Huntington Life Sciences. The theory being that if they could get to the suppliers of Huntington Life Science, that they would not be able to conduct business. So Marsh, which is an insurance company, was targeted, and what they would do is they would go to the residences of the executives of these companies in order to get them to disassociate from Huntington Life Sciences. And they were very successful. Marsh Inc. left HLS. Deloitte & Touche, one of the big four accounting firms, left HLS. Board members were leaving HLS. And the coup de grace was that they delayed the relisting of the parent company of HLS on the New York Stock Exchange. So you can just imagine, they were not very happy. And this anonymous ad was shown. Totally anonymous. Nobody wanted to take responsibility for this. And this is supposed to be an animal activist with a balaclava. Unfortunately, nobody told the person who was sitting for this, or the photographer, or the people who put this together, that animal activists don't wear leather jackets. So much for truth in advertising. These kids were tried in the Third Circuit. in Trenton, New Jersey. Do you know where Trenton is? It's in the heart of New Jersey, the heart of the pharmaceutical industry. Do you know who promulgated the AETA? The major proponents were the pharmaceutical industry. So what do you think the court is going to go for? They're going to go for the homeboys. So what they did is they found that there was no real direct evidence of wrongdoing, no direct evidence of conspiracy, but the convictions were affirmed by the totality of the circumstances. We're talking about course of conduct, 2 or more acts evidencing a continuity of purpose, ideology. You have a demonstration. People have a similar ideology. Some people are engaging in legal activity and others are engaging in low-level criminal activity. It's the totality of the circumstances. We couldn't find the people who did the act, so your names are advertised, and so we're going to target you, so tag your it. This was guilt by association. The direct action goal, they said, was to shut down Huntington Life Sciences. And they said that anyone with a shared ideology acting in agreement was engaging in criminal conduct and conspiracy. What conspiracy? They weren't agreeing to conduct illegal activity. So does that make any sense? And the illegal activity that the court found was black faxes. Do you know what a black fax is? I didn't know okay, so one person knows what a black fax. I didn't know what a black fax was. 2 people. A black fax is you take a black sheet of paper and you put it in the fax machine through a continuous loop so the other side runs out of ink. Kind of electronic civil disobedience. That was the illegal act. And they even indicated that one of the activists, Josh Harper, engaged exclusively in protected First Amendment activity. But the conviction for this made-up conspiracy was upheld. And when I say made up, it's because there was no evidence that there was actually an agreement for illegal activity to take place. But it was nonetheless upheld because of his friendship with Kevin Jonas, which was another activist, and his longstanding political and personal support for the cause of animal rights. Does that sound like ideology to you? Does that make any sense at all? Do you see how nonsensical this statute is? There were 3 judges who made this, who were sitting on the panel. One of the judges dissented, Judge Fisher dissented. He said the government never proved its case. Even viewing the evidence in the light most favorable to the government, no rational trier of fact could have found the essential elements to violate the AEPA beyond a reasonable doubt. Unfortunately, the other 2 judges weren't as smart. Next. The verdict was 1 to 6 years in federal prison, $1 million, $1 in restitution. I like that $1, I don't know what that's supposed to mean. And they were all in prison under a terrorism designation. Now, where did they get $1 million from? I just mentioned $50,000. Okay, $50,000 does not equal $1 million. The defense counsel were constantly asking the court for substantiation for evidence indicating the $1 million mark. No evidence. And the court still upheld it. They were defending the homeboys. It's so important where cases are brought, the venue, the jurisdiction, and the prosecution was able to bring it into a jurisdiction where they were going to get the best results for the prosecution. So who were the Shack 7? Exactly the Shack 6. From left to right, Andy Stepanian, Lauren Gazzola, Kevin Jonas, Josh Harper, Jacob Conroy, and Darius Fulmer. They look like they just graduated from college. They're going to their college reunion or something. Lauren Gazzola wrote, I was 3 weeks away from taking the law school admissions test in 2004 when I was arrested and charged with domestic terrorism. I hadn't hurt anyone or vandalized any property. The indictment didn't allege that I committed any independent crime, only that I conspired to publish a website that advocated and reported on protest activity against a notorious animal testing lab in New Jersey. So great, so now they're targeting potential law students. They're really going after terrorists now, right? No. And this particular result violates the First Amendment right against guilt by association. The Supreme Court has made it very clear in two landmark cases. The NAACP case dealt with the civil rights movement, and NAACP went down to Mississippi. They organized boycotts against white-owned businesses. The speech was very high rhetoric, and they kept saying, if you cross these picket lines, we're going to break your expletive necks. There was violence that ensued, but the Supreme Court was very clear. The people who organized this, the NAACP, was not responsible for any of the violent activity that occurred. No guilt by association. Brandenburg versus Ohio, that was the Ku Klux Klan. The Supreme Court said that you cannot be liable unless you're inciting people to imminent lawless action. Was there imminent lawless action by the Shack Seven? No. Was it guilt by association? Yes. Completely violated the First Amendment right against guilt by association. Then in 2009, there was the US versus Brandenburg indictment, and there were 4 kids in Berkeley, California protesting at the residences of vivisectors. Now, I'm sorry, but if you can't protest in Berkeley, California, you can't protest anywhere. The charge was that they were intentionally placing people in reasonable fear of death or serious bodily injury through threats, harassment, or intimidation, and they were facing a maximum penalty of 5 years. Great. And what were they doing? Well, the criminal complaint stated they were protesting, chanting, using a bullhorn, conducting internet research, leafleting, wearing bandanas, and chalking up the sidewalk. Is that a threat to anybody? No. So the judge said, okay, so you give me an indictment, you give me a criminal complaint, where are the facts? And the judge said that the government will rely on the defendant's conduct as a whole, again, guilt by association through the totality of the circumstances. If individual acts did not amount to a threat or an act of intimidation or harassment, what conduct as a whole did? The judge said, case dismissed. Come back with a better indictment. They didn't have a better indictment to come back with. But the mission was accomplished by the government, and that was to stop First Amendment speech and assembly. People were taken off the street, one was placed under house arrest, and they were all placed in prior restraint. And it sent a message, a clear message to everyone in the community. Don't do this, otherwise the same will happen to you. Now, what Judge White said in that case, so it was something very interesting. He said that ADA doesn't just apply to animal activists. It can apply to anyone, including workers. You see, ADA is a very broad statute. It can apply to anyone, but the Department of Justice has indicated that they're only applying it to animal activists. Does that make any sense? No. These are the 4 kids, and one of them was a law student. Okay, so now they're going after law students and prospective law students. Are they the terrorists, the modern day terrorists of today? Then there was a challenge to the AETA in the First Circuit. And the First Circuit said that there was no specific harm suffered by the plaintiffs, and therefore they could not find anything that was unconstitutional about the statute. The ACLU and the New York City Bar Associations filed amicus briefs in support of the activists. So what are animal enterprises? Well, first of all, they're treated as a protected class. Why are they treated as a protected class? Does that make any sense? And yet they're recidivist violators of the Animal Welfare Act. The pharmaceutical industry and the animal testing industry are constantly being found in violation of the Animal Welfare Act. And a lot of pharmaceutical industries definitely outsource them to other places. So animal enterprises can be the usual suspects: circuses, pet stores, puppy mills, factory farms, animal testing labs. But there are also those that are not so usual. Automobile makers. They sell cars with leather seats. Department stores. They sell fur. Luncheonettes. They sell eggs. Porn shops. They sell leather outfits. Jerry Friedman really encapsulated the irony of this statute. Vandalizing a circus billboard makes the vandal a terrorist, but vandalizing a circus protest sign remains a petty state crime. And this is all based on ideology. So does that make any sense? No. So you're probably wondering, how did this law ever get passed? Well, it was decided that it was non-controversial because both Democrats and Republicans supported this bill. Therefore, the House and the Senate were able to suspend their normal rules, and as opposed to the entire House voting yay or nay on the bill, only 5 votes were required in order to have a unanimous vote on this bill. And the go-to people, Bobby Scott and Dianne Feinstein for Civil Liberties, were on board with passing the AETA. The American Legislative Exchange Council was very involved in putting this together. They had put together a model anti-terrorism legislation, and ADA was largely based on their model. So what do animal activists do? Well, they protest for the animals, you and the planet, go vegan. This is the anti-fur protest at Schumacher Furs in Portland, Oregon, and after a year, they were able to get Schumacher to close down. This is someone protesting pigs going to slaughter, and here's a KFC protest. So why is it important to speak out? Well, the Kansas State University study, which primarily focuses on animal agriculture, said that media attention to animal welfare has significant negative effects on U.S. meat demand. And they said that increasing media attention to animal welfare issues triggers consumers to purchase less meat rather than reallocate expenditures across competing meats. So it's very important to get the media attention out there for people to know about the issues. So what happened with these industries? Well, they started to come up with ag bills. They wanted to criminalize on the state level any videotaping or photographing of factory farms, because they understood that undercover videos really affected consumer demand. These are also ALEC-inspired bills. Do you know how many bills were introduced in 26 states over the past number of years? It's been 46 bills. Most of them have been defeated. And it's not punishing the abusers, but those who are exposing the abuse. Now, does that make any sense? No. And indeed, the first time that an ag law was put into effect was in Utah, when Amy Meyer, who was standing outside of a factory farm on a public street across the street, was photographing farm animal abuse from a public road. Once it was known that she was indicted, people were outraged. The prosecution ultimately withdrew the case. It's interesting, the Animal Agriculture Alliance stated that we don't need activists to police us, we can do it ourselves. Yeah, sure. Enact ag bill so people don't know about the truth. And Will Potter, who is an award-winning journalist and author of Green is the New Red, said that the biggest threat facing big ag isn't that activists are breaking windows, it's that they're creating them. And so why is the First Amendment important? Well, if we lose our voice, who's going to speak out for the animals? And this is our mascot, Charlie. He was a rescue. So if they tape our mouths, they're basically taping the animals' mouths. I encourage everyone to read the book Green is the New Red, An Insider's Account of a Social Movement Under Siege by Will Potter. It's a great read. And just coming back to the theory and the dichotomy between liberty and security, the more security that people feel that they need, the less liberty we're going to have. And our freedom comes at a price. It is not free. And we have to use it or we lose it. And as Benjamin Franklin said, those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Now I'd like to ask our moderator, do we have a few minutes for a video, or do you need to get on with the program? Because I know we started a little bit late. Yeah, okay, great. We're going to show you a video. We don't really have audio video here, so I'm going to take my mic and we're going to show you a little film that we put together for the repeal of the Animal Enterprise Terrorism Act. Does anyone know where that is? Is that in Utah somewhere? That's a great.
It takes money away from